Good afternoon. I want to welcome the jury pool to Ask Two Lawyers. Looks like people have already been.
Oh, somebody must have their YouTube up. And it would be me.
Doing this live. We do these live, Keith, because we want to be unscripted.
Yes.
And we don't want anyone to say we edited something.
Yeah, we like to just give you our thoughts as we're going through this stuff. But I left my YouTube on, so that caused a feedback.
Well, I want to welcome our jury pool. It looks like a lot of good comments are already being tossed back and forth. We have people from New Zealand, from Australia, Canada, Ireland, England, Scotland, and all over these United States. It's awesome to see everybody. We're excited that you're here. And Keith, I told my family today, I normally spend time with my family on Sunday.
Right.
I was like, I got to go do a video today.
I know.
And so this is where we're at.
Yeah. I mean, I think we both felt like it was important that we kind of circle back and maybe go through this information a little slower, a little more carefully. And, it's funny because if you want to learn about the law, this is a great case to do it because it's complicated. It's federal court. It's choice of law. There's a lot going on in this case.
There's a lot going on, and I think the majority of people knew what we were saying. I think it was Thursday when we went over the 12B6 that was filed by Blake Lively, and I still stand by Ezra Hudson being a fantastic legal writer, and I'm sorry if I'm a fanboy, but she did an excellent job, and I would say that about any lawyer. When you and I are working on cases and an opposing lawyer sends across a piece of good work, how do we review it?
Well, you have to know your opponent, right? You have to know your adversary. So if you stick your head in the sand and you don't admit that, oh, this is good, then you're going to be in trouble. You're going to lose. So you have to recognize good work when you see it. And, we're not saying that we support Lively or Lively's side of the case just because we appreciate what this lawyer did. But you do have to recognize good legal work when you see it, because if you don't, it's going to bite you in the rear.
Yeah, something else we're not saying is that we agree with California law or New York law or Florida law or any law. It's really not a moral decision for us to make. As lawyers, we look at laws and we see if they apply to the facts.
Yeah.
And if they do, then we have to figure out, are we going to use this law to help our case? Or are we worried that the law on the other side is going to hurt our case?
Yeah, and that's why we spend so much time looking at the weaknesses of our case, and we call it turning the crystal. And so you have to sit there. In fact, we spend way more time on the weaknesses than the strengths, because the strengths are kind of easy. Like, what the strengths. But good lawyers will spend a lot of time on looking at the weaknesses of the case, turning the crystal, looking at it from every little angle to figure out, how can we get around this? How can we minimize it? How can we reduce the risk of that? And that's really where lawyers make their money.
And it's painful to look at your Achilles heels.
Yeah.
It's painful to look at the weaknesses of your case.
Especially when they first slap you across the face.
Yeah, but you have to do it.
You have to.
You have to look at the weaknesses. Now, some people in the jury pool said they just couldn't stand it. And for those people, we respect you. You do not have to watch us. We love to have these discussions. And by the way, these discussions are our hope to educate where we can. And not that we're up on high here, because we make mistakes too, but we want to educate the best we can. And we really want to get you, the jury pool, discussing this. And we want you talking about CCP 47.1 and CCP 47 and 48A, and what is actual malice and what is a communication. And we want you guys to be educated. We're trying to arm you as our jury pool to go out and have intelligent conversation with your peers about this case, and it only will make you stronger. So hang in there with us. As uncomfortable as it can be at times, there's also moments where it's just a lot of fun and you have clarity of thought and you have a good discussion with somebody.
Yeah, and we have utmost respect and confidence in our jury pool out there that you can hear the pros and the cons, and you can think for yourself. You're independent thinkers. And I noticed, I was watching, and I think you did too, Zach Peter yesterday, and he made the comment of, no, it was good that Ask Two Lawyers are bringing up these issues so that we can think about it, and then we can think, well, how would Baldoni argue to get around these things, or where's the issues? And Zach actually did a really great job of kind of summarizing what the issues were. He's a very smart person, and he did a fantastic job with it.
Yeah, I thought he did a good job. It's funny, somebody asked him a tricky legal question, and I saw him doing the math in his head, and he literally reverse engineered it, and he gave the right answer.
Yeah.
And he's not a lawyer, and it was awesome to see that, because he's taken time to think about this case. He's a layperson that has dug into it. And by the way, when we have juries make decisions in 99% of cases across the nation, these are non-lawyers that are making very big decisions based on the facts and the law.
Yeah, and Zach's not one to shy away from the pros and the cons. I mean, he'll dig into everything, and I think that intelligent people do that. And that's our jury pool. That's the faith that we have in the people out there who's listening to this.
So we want to jump into just a little slower analysis of what we went over the other day. It's going to be a shorter version, but we want you to throw your questions out. We have producer Eric here today. He'll interrupt, and we want to answer your questions because there were a lot of people that had questions that weren't answered. And to the extent we can answer your questions, we're going to do that. I know there's been other lawyers that have commented on this case. I saw one or two of the lawyers commenting on this case. Let me just say this. Everyone's trying here. I think everyone's trying to do a good job. I'm not going to tear down anybody. I saw a non-lawyer the other day, and they have a YouTube channel, and they were earnestly trying to explain some issues pertaining to this case. I personally disagreed with many things they had to say.
But kudos to them for trying.
And they were so earnest, and I really enjoyed listening to them.
Yeah.
And I learned a lot from listening to them.
Yeah.
And so I would hope that as a community here, we all can work together. We can throw things out there. And to the extent, again, it's too painful for you. Oh, Zach Peter.
Yeah, Zach's in the house.
All right.
Nice.
Nice to see you. Wait, we love you too, Zach. Thanks for the shout out yesterday. So let's jump right in. Just as a nutshell, Keith, if you were to sum up the 12B6 motion that's been filed by Blake Lively here, she's saying that it needs to be, that Justin Baldoni's case needs to be thrown out based on the fair reporting privilege, based on the litigation privilege, and based on the SH privilege under California law. Is that a fair representation?
It is, but I want to be very clear, and we'll probably clarify this multiple times for this video. I thought we clarified it before, but maybe we didn't. What we're talking about is Baldoni's countersuit for defamation. We are not talking about Baldoni's ability to defend himself on Blake Lively's complaint for SH. He can defend himself against Blake Lively's complaint for SH all day long and not trigger any of these privileges, especially 47.1. Has nothing to do with the defense of the SH claims. This only has to do with Baldoni and the Wayfarers party's affirmative counter claim that they filed for defamation. There's a few other claims in there besides defamation, but the big ticket item was defamation. That's what we're talking about.
So just to be clear and not to be too redundant here, Keith, it sounds like Blake Lively sues Baldoni and team for SH.
Right.
Baldoni and team are allowed to use every tool available to them under law to defend against that. And 47.1, there's no SH privilege out there. There's no fair reporting privilege. There's none of those privileges that will keep them from defending themselves against the lawsuit that has been filed by Blake Lively against them. Is that right?
They can mount a vigorous defense, and they can, their attorneys can engage in zealous advocacy, all the stuff that attorneys are supposed to do, and won't trigger 47.1 for the defense side.
So just like in football, there's an offense and a defense. From a defensive standpoint, Justin Baldoni and his team can protect themselves, defend themselves against these claims that have been made by Blake Lively. However, the issues that we were talking about the other day and the 12B6 focuses in on is the actual offensive. And I don't mean offensive in bad. I mean the offense that Team Baldoni did in filing a claim, a lawsuit against Blake Lively for defamation.
Yeah, that's right. Yeah, it's a countersuit that's the subject of the motion to dismiss.
And if you remember, we talked about on Thursday that the reason the California legislature passed this, and I'm not standing up for the California legislature, but the reason they passed this law was because they didn't want victims of SH being countersued for bringing their claims forward against employers or very powerful people. And so generally how this would happen is and Keith, you and I have handled many sexual harassment claims or SH claims in our history. And we've seen what the defendants do to our female clients during a year and a half or 2 years of litigation. And it's awful what they do to them. I was
just reacting there because, it is hard to say SH all the time. We're not used to it. I mean, apparently that's what you're supposed to do on YouTube. But it is terrible. We have been involved in cases. I guess we can't go into the details, unfortunately. But, you figure a vast majority of the time, this is a perfectly good law because we want to protect people who are not in a position of power from being countersued by people who are in a position of power and who have money, way more money than the victims, to go after them.
And that leads into some comments I saw online saying, well, but Blake Lively is wealthy and she's famous.
Yeah.
And because of those two reasons, this law cannot apply to her. Is that
but it does, because the law applies to everybody.
So there's no exception in this law that says if you have a certain amount of money, it doesn't apply to you?
No, yeah, it's not like if you've won 2 Emmys and you've been on 3 blockbuster films, it doesn't. No, it applies to everybody.
Yeah. So and that and again, we're not saying from a moral standpoint whether that's good or bad, but it is the law in California. And if California law applies to this case, then it is something that will have to be dealt with.
You have to deal with it. Yeah.
All right.
And that's the thing with lawyers. You have to play the hand you're dealt.
Well, why don't we go ahead, Keith, and let you walk us through the fair. Let's take a look at 47.1. Let me pull this up and let me do a call out here. So this is the new law. It was passed in October of 2023 in California in the legislature, and it became a law on the books on January 1 of 2024. And this is the one that's causing everybody heartburn.
Yeah.
And there's these 3 paragraphs here, A, B, and C. Why don't you walk us through this and slowly, let's go slow and see if we can understand everything that the law touches.
Yeah, and it's interesting because it all starts with A. And we pointed this out a long time ago. I remember one of the first times we talked about this case, I think we were on with Zach Peter, and we pointed out this 47.1 over a month ago, probably. And so if you look at what A says.
Can I just interrupt? And I apologize because I really want to get into this.
Yeah.
But really what we're talking about here is there's the litigation privilege under 47, section 47, right?
Yeah.
And that litigation privilege is enhanced and applies to 47.1.
Right.
Okay, so let's walk through 47.1.
But think about just how enhanced it is, because the normal litigation privilege is if you file something in court as part of your complaint or an answer or anything, motion, anything you file in court is protected by the litigation privilege. You cannot be sued for defamation for what you say in court. But look what A says, a communication made by an individual without malice regarding an incident of SA, SH, or discrimination is privileged. So it's not even a filing, it's a communication. So the word communication, which you underline there, that takes the privilege and expands it so broadly now because any communication falls within this rule.
Can I ask you to help me understand that fully? So under section 47, which is Code of Civil Procedure 47, there's a litigation privilege, but there actually has to be a filed complaint in that case, right?
Yeah, there has to be a filing with the court.
Okay. And here, what you're saying is it doesn't have to be a filing with the court. It just has to be a communication.
Yeah, I mean, I could write a handwritten note right now that says that, yesterday I had an incident of SH. I could hand it to you. I could post it online. I could give it to the New York Times. I mean, this is the problem, is any communication made by an individual. Now, it does have to be without malice. So there is a qualification. It's not at what we would call an absolute privilege because it has to be a communication without malice. And of course, we'll get to that.
So we call this a qualified privilege, right?
It's a qualified privilege.
It's qualified on the what am I trying to say? If it doesn't have malice, then it works. But if it has malice, it doesn't work.
Right.
So it's qualified.
That's right.
Absolute doesn't care if there's malice, right?
No, it doesn't. And the question here is what is considered? Yeah. Anything you say or write. I mean, a communication is what you'd imagine it to be: emails, text,
smoke signals,
carrier pigeon. I mean, anything you communicate out of your brain.
And there actually is a definition in the statute that defines what a communication is, and it's extremely broad. And that's the point I think you're making here.
Yeah, that's the point. Yeah, that's exactly the point. So this is the starting place that we have to start with is a communication made by an individual regarding an incident of SH. Boom, done. I mean, that's how broad it is.
And it has to be without malice, which we'll get into in a second.
Yeah.
Okay.
So let's skip down to C for a minute.
Okay.
And so it says the section shall only apply to an individual that has or at any time had a reasonable basis to file a complaint of SH, whether the complaint is or was filed or not. So that means looking back in time, if there's any moment in time, even just if it's one day, if there was any moment in time, 1 minute, when they had a reasonable basis to make an SH complaint, whether they made it or not, whether they filed it or not, this statute applies to them. So again, super broad.
I mean, and I think this is where we've seen a lot of people talking about the CRD complaint and whether, there was some gamesmanship there, and there may have been gamesmanship there.
Yeah.
But even if there was gamesmanship, and we're not sure about what's happening there. Did the CRD complaint have to be filed in order for 47.1 to provide protection?
No.
Did
That's
not.
what's so crazy. Look at C. The CRD complaint didn't even have to be filed to afford protection. What happened with the CRD complaint being filed is now you have protection under both Civil Code Section 47 and Civil Code Section 47.1.
So if we look at subsection C again, we see there, let me grab my laser pointer here, see if this works. So it says that the section shall only apply, and it says that a person has to have a reasonable basis. And there was some confusion about the 12b-6, where there was things being mentioned that the asked two lawyers were saying that the 12b-6 was going to be successful and the case is over. I want to be clear, we never said that, number one. And number two, we don't believe that the 12b-6 is going to be successful and that the case is over. But we do believe that section 47.1 will be through the case through all phases, including the trial phase, and it is a game changer. And we're going to talk more about that in a minute. But we want to point out that the reasonable basis, we believe that's a factual determination. And Keith, there are factual determinations and there are legal determinations. Can you walk us through who gets to make those determinations and which ones are made at the 12b-6 phase?
Only matters of law can be decided at 12b-6. And even then, it's further limited. Only matters that are disclosed or stated on the complaint itself. It's very technical motion. So let's just say for a moment, and we'll get to an example of this, but let's just say that Blake Lively's motion to dismiss is granted. That doesn't end the case because the court's going to give Baldoni the right to amend, and he'll simply amend. And then all he has to do is put the proper allegations in his complaint, and it will move forward. Ultimately, only a jury can decide questions of fact. So when you talk about things like reasonable basis or without malice, those are things that are factual determinations for a jury. So we can argue about, will the motion to dismiss be granted or not granted? I think 47.1, is a big issue regardless of whether the motion to dismiss is granted or not granted. But this is not case over at this stage of the game because Baldoni can simply amend.
And I think Brian Friedman did a good job the other day of coming out and saying, look, we answered this case. Oh, go ahead. Sorry.
Well, Eric just put up, she's not in California. How can she be protected by FOIA? We're going to go over choice of laws in a minute.
It's because Sony Studios is the employer and they're California based?
No, I mean, it's based primarily on the arguments that the Wayfair parties made when they opposed the New York Times motion to dismiss, which is they came out and said, look, we are California people. We work in California. We live in California. Therefore, the defamation should be decided under California law. And the reason they did that is that they wanted what? False light?
Yeah, it's not just that they claimed California law in the New York Times that you just outlined perfectly, Keith. It's that they've included causes of action under California law in their filing.
Oh, the Wayfair parties.
Yes, correct.
Yes, right.
And so once they did that, they're availing themselves of California law.
And federal courts do these conflict of law analysis every day because of diversity jurisdiction.
Yeah.
I mean, you have a plaintiff in California, a defendant in New York. What law is going to apply?
Right. Let me get back to my point I wanted to make about Brian Friedman, and I think it's important. It's an important point. He answered Wayfair, Baldoni. They answered the lawsuit against them, right?
Yes.
And he said, I'm not going to file these 12b-6s that we're getting from these other people, the New York Times and from Blake Lively. And it's important. We as lawyers at times, Keith, we choose not to file demurs, which are essentially 12b-6s in California state court.
Yeah.
And the reason we don't want to file demurs, why don't we want to file demurs if we're going against somebody that we don't think really maybe understands what's going on here?
Because you educate the other side. And so there's a strategy to it. And a lot of times you're not going to win a demur or 12b-6 without leave to amend. The other side is going to have a chance to amend and fix their pleadings. So why let them fix their pleadings? Just let it go.
And that was Friedman's point. He said, look, we're going to be able to plead around these because these are questions of fact. Did she have a reasonable basis? Was there actual malice? We're going to somehow be able to get that through a second, third, a fourth, a fifth amended complaint. And if we can get around that and pass this 12b-6 phase, then those will be issues for the jury because we all know that juries make factual determinations, judges make legal determinations in jury trials.
But you can't deny that the countersuit that Baldoni brought against Lively for defamation is a whole different ballgame under 47.1 than it would have been a couple years ago before this law was on the books.
Absolutely. And it is a game changer. So why don't we look at B? Because I think this is where the rubber meets the road.
This is the risk that Baldoni and people in his position or her, whatever position you are in when you're doing a countersuit for defamation, this is the position you're in. So a prevailing defendant in a defamation action. So that means it only applies to Lively. It doesn't apply both ways. This is not a two-way street. There's a one-way street.
So when it says a prevailing defendant, here under this statute, the prevailing person would be, if she is, it would be Blake Lively.
In the countersuit for defamation.
Correct.
Because on the countersuit for defamation, Baldoni's plaintiff and Lively's defendant.
Right.
And so in that instance, so he could win his complaint that Lively brought for SH. No problem. He could win that. But he could also lose his countersuit for defamation. If he does, this is what happens.
And so if he loses under 47.1, essentially, then tell me what happens.
He has to pay all of Lively's reasonable attorney's fees and costs for her successful defense of his countersuit for defamation. He has to pay treble damages, which is just triple damages, for any harm caused. And then he also is exposed potentially to have to pay punitive damages. I mean, those are three big hammers, three big sets of damages that normally the prevailing party does not get in a lawsuit.
That's true. And Keith, when you and I have a similar statute, and there are similar statutes out in California that deal with this, where it's not dealing with SH, where attorney's fees and treble damages and punitive damages are granted to the prevailing party in a case, but not to the other side. If you're representing the other side that doesn't have these claims available to them, these remedies available to them, we as lawyers must sit down and walk through with them very carefully. And we even put it in an email and a letter to them that we've gone over these things. These could be significant damages that you will have to pay at the end of this case.
Yeah, that's right. And so what's happening here is that it's an unfair fight. Baldoni and the Wayfarer parties are exposed to damages, even for not prevailing on their defamation countersuit, that the Lively parties are not. And so one way to look at this, I suppose, is that, Baldoni and Wayfarer, they're even more courageous than we thought they were, because they're going to have to take on this big burden and this big risk moving forward. Now, I know that they have the billionaire on their side,
Steve Sorowitz.
So maybe Sorowitz kind of helps them take on this risk, but it is a risk nonetheless.
It has made me chuckle a little bit inside. Again, I don't want to demean anybody's analysis of this case, because I do believe everybody should be doing their best. But I have heard several lawyers say recently in interviews, oh yeah, this 47.1 thing is nothing to worry about. What I would say to those lawyers is, are they willing to sign an indemnification agreement on behalf of Justin Baldoni, that if this comes to fruition, they'll pay his legal fees and the punitive damages and the treble damages? It is a significant issue, and it has to be analyzed. And of course, Brian Friedman, he's a good lawyer. We haven't discounted Brian Friedman. He's going to come out and say, oh, this is a bunch of hooey. We're going to be able to, prove the facts in this case. And of course, that's what you say when you're in the litigation. But this is something that he will have to have a conversation with Justin Baldoni and the other clients he has regarding what the risk, the exposure is, if somehow, some way, Lively becomes the prevailing party.
Yeah, and they will, and they do have facts, I think, that do go towards the whole malice arguments. But you still can't get away from the fact that they're taking on a big risk here. And it's easy to downplay it if you're not the one who has to pay that out of your own pocket. I mean, it's the person who's on the firing line. I mean, they've got a big decision to make here.
Again, Steve Sorowitz may make that easier for everybody. If you're a billionaire and you've got $100 million and you truly are willing to burn that, well, I suppose that that helps in that regard to some degree.
Yeah, I mean, most of us don't have a billionaire on our side, but.
And Keith, and then I'm not sure if CCP 48A is the actual malice definition that would be given to the jury in this case to consider, but it's what essentially Blake Lively's lawyers point to in the 12b-6 as the definition of actual malice, if you want to show it. There's also jury instructions that will be drafted based on case law, based on other definitions that will be presented to the jury for them to consider if this goes all the way to a jury and they need to determine was there or was there not actual malice. They're going to be given some definition like this, but this is pretty close. Walk us through this definition.
Yeah, and I think the first part, that's where it means a state of mind. Malice really just comes out of an intent, and it means a state of mind arising from hatred or ill will towards the plaintiff. So what you're saying is you have to prove that Lively had hatred or ill will towards Baldoni. Okay, well, I feel like we have facts that go to that. And I think ultimately the jury is going to have to decide, do those facts rise to the level of hatred and ill will? And then, but there is an exception. However, the state of mind occasioned by a good faith belief on the part of the defendant in the truth of the libelous publication at the time that it's made does not mean actual malice. So if Lively had a good faith belief, if the jury thinks she had a good faith belief that what she was saying was true at the time she said it, not now, but at the time she said it, then that would not be malice by definition. So you can see how tricky that can be.
By the way, when we were young law students back in the day, we got into these negligence crimes and we got into intentional crimes. Intentional crimes, those are things like you mean to kill somebody. You put it in your head, I'm going to kill this person, and you do it. Driving down the road and not seeing somebody and running across them in a crosswalk because you didn't see them, that's what we would call negligence. You still can get in trouble for it, but it's not intentional. You, in your head, you didn't have an assessment in your head saying, I'm going to kill this person.
Yeah.
The interesting thing about malice is people have to look at what's inside your head.
Right.
It's a hard thing to do.
Yeah.
And conduct alone is not sufficient. You have to look at the frame of mind. And so, look, this is tricky. I think that the jury pool here, I think there's more people listening to our jury pool that will say, oh, this actual malice thing is going to be easy to prove. I disagree. I don't think it's going to be easy to prove. I think it can be proven. But I think it also can be proven that she reasonably believed what happened at the time. And if a jury were to buy that, that would be a problem for Justin Baldoni.
Well, first of all, if you're going to look inside my mind, you're going to clear out the cobwebs first. But I mean, really what we're getting to is what is the state of mind here? And the way you prove that is by circumstantial evidence through actions, right? So what actions did Lively take that would lead towards malice? I think we have facts here for that. I think that there were things that she did in terms of, being disingenuous, taking over the movie, all those allegations about those things. I think that can go to actual malice. And then reasonableness, that's ultimately going to be for the jury to decide.
Wanted to talk about this one. How is privilege different to attorney eyes only?
So there's a lot of different privileges in the legal world, because there's attorney-client privilege, there's financial privilege. Does that mean like attorney's eye only, like for the protective order?
Yeah, I don't see the two related. Attorney's eyes only is a protective order issue, and it has to do with certain documents that cannot be seen by the parties. The privilege here would apply to everybody, presumably, unless you can show the privilege does not apply.
So the attorney-client privilege is a little different from the litigation privilege.
It is.
Because attorney-client privilege helps you not disclose things to other people.
Right.
The litigation privilege doesn't do that.
No.
So what's the difference? What does a litigation privilege do?
So the litigation privilege, the idea there is we want people to bring their claims in court. And if they say it within the confines of bringing a claim in court, whether it's through depositions, discovery, pleadings, whatever the case may be, you can say even outlandish things. If I sued you, Keith, and I said, Keith Davidson, he doesn't even love his family. He doesn't care for his family. He's the most horrible dad ever. And none of that has any truth. I'm just trying to impugn your character and your reputation. You can't sue me for that, for defamation, because it's in the confines of the litigation privilege.
Yeah, it's pretty broad. It's pretty crazy.
Yeah. Keith, you put together some decision trees, and I think it'd be nice to run through those real quickly for the jury pool. And then Eric, we just want to answer just a ton of questions. So anybody has questions, please put them up.
Yeah, I thought this one seemed pretty intelligent. It seems maybe someone's studying up, but Gwen D says, can Justin use tortious interference with prospective economic advantage, or can Baldoni file for IIED, emotional distress, before the judge rules on Lively's motion to dismiss?
What are your thoughts?
I mean, he could, and he certainly can. He can amend before the judge rules on any of these motions to dismiss. There's 3 of them right now. There's the New York Times, there's Leslie Sloan, and now there's a Lively. Oh no, 4, Ryan Reynolds. So a second amended complaint would get rid of all of those motions to dismiss, and you can include other claims. But again, 47.1 is going to apply for whatever claims.
That's also an important point, Keith, that I hope we made the point strongly in our presentation on Thursday. And that is 47.1 only applies to Blake Lively.
Yeah.
It does not apply to the New York Times has a fair reporting privilege, which is like 47.
But it doesn't come with damages.
Doesn't come with damages, and it doesn't have to do with SH.
No.
So 47.1 does not apply to the New York Times. It does not apply to Ryan Reynolds either.
No.
Only to Blake Lively.
Yes.
Because she made a claim for SH and a countersuit came in by Team Baldoni for defamation.
Yeah. Ryan Reynolds cannot use 47.1.
How about this from Lena Wan says,
Nice.
greetings from Canada. Love your analysis of this case. Question. There's been so much back and forth on this case. At what point does a judge say enough and possibly move up the court date? I think that's what people want, but who knows?
Yeah, I don't think that's going to happen. In fact, there's a chance the case trial date gets put out. Although federal courts are very strict on their trial dates, there's just so many moving parts in this case right now.
Well, how many 12B6s does this judge deal with on a weekly basis?
I mean, this is par for the course.
Thousands.
I do think that Brian Friedman made a really good point, though, and that is 12B6s educate the other side.
Yeah.
And so now I don't know that Brian Friedman was completely focused in on 47.1. He may have been. But if he wasn't, he is now.
Yeah.
And so now as he prepares for trial, as he prepares for responding for motions for summary judgment down the road, which is another paper war to get the case thrown out before it gets in front of a jury, he now is honed in on the issues that he needs to focus on.
I mean, Friedman and his team are definitely turning the crystal, as we call it, on all of these issues. And they're going to keep on doing it because good lawyers, figure out ways to shore up weaknesses.
So Keith, you put together we have another question.
While you're pulling that up, Renee said earlier, this was kind of when we first started, but I thought it was a good question. She said, have you read the timeline of events? Do you think it is sufficient to prove malice? And I don't know if there's one end all be all, if anyone blogged a big timeline that you guys have read at all, but
yeah, I mean, we've read a lot of different timelines, that's for sure.
I think she may be referring to Exhibit A that was filed with all the text messages. I mean, really what it's going to come down to is the definition of what actual malice is, and that a jury has to make that determination. It's a subjective determination. A jury gets to make that. They're going to be back in the deliberation room talking about what the definition is, and they're going to see the people testifying. I have said from the beginning that if you can put Blake Lively on the stand, and of course, take a really good deposition of her. The deposition is more important than putting her on the stand. Mm-hmm. It's taking a really good deposition of her, showing where she's lying or being inaccurate or overstating things. And if you can do that, then you put her on the stand and you show the jury that they can't believe her. She's not credible. Maybe even an outright liar is what you want to show the jury she is. And then there's that one jury instruction, a fantastic jury instruction, which I'm sure the defense will argue heavily on Blake's side, saying you can't use. I think the judge will allow it. It's a jury instruction that says if you find that a witness lies on a single point in their testimony, you can discount everything else they're saying. And so that leads into the 47.1 analysis, because Blake Lively is going to be saying a lot of things about the facts that lead up
and
to
her basis for it.
her basis. And if you can get a jury to say she's just a liar, a cheat, and a fraud, and I'm not saying that she is, I'm just saying if the jury were to say that, then the jury could say, hey, we're not going to listen to all this. And so 47.1, yeah, we find actual malice, and we find she wasn't reasonable. She didn't have a reasonable basis to bring it.
Yeah, that's right. And I guess if you were to think about that Exhibit A, do you think that there's some facts in there that could allow a jury to find actual malice if it feels like that's what it wants to do?
I mean, there's so much in that Exhibit A. I'm sure you could find something to point to. I mean, it's a very fact-intensive case at that point. And I really think it's going to come down to, does the jury like Baldoni at the end of the case? Did this jury like Blake Lively? Do they like Ryan Reynolds? I mean, these are all actors, so that'll be interesting. They'll be more polished than many other people. Let me throw one example out there. Rudy Giuliani. I don't think too many people like Rudy Giuliani. I apologize to anybody in the jury pool that likes him. I don't dislike him or like him. But there was a lawsuit against him for defaming two employment or two voter registration folks in Georgia. And they got they got like $180 million judgment against him. So the jury clearly did not like him. And so they awarded significant damages. That's a completely different case than this case. I just want to point out
the point.
The point is that juries, if they like somebody, it's hard for them to hurt that person. Like Johnny Depp. I think everybody liked Johnny Depp and nobody liked Amber Heard. That was just a tough case to win for Amber Heard.
And juries can find actual malice if they feel like that's the right decision. And that's the great thing about juries, is that those 12 people will figure that out. Cam Freeman requests New York law to apply to Lively case, even though he requested California for a New York Times case.
What do you think?
He can. I mean, the court is allowed to apply choice of law to different claims. And so just because the claims against the New York Times would be California law, for example, the judge could say, yeah, but these other claims should be New York law. So every claim can have its own choice of law provision or selection in it. But what Lively's motion pointed out is that Baldoni and the Wayfarer parties argued very strongly in their opposition to the New York Times that California law should apply because they wanted that false light cause of action. And so Lively's just saying, well, if they wanted it for defamation against the New York Times, then they should have it for defamation against Lively. So that's their argument. So it'll be really interesting to see how the judge decides on that. But did you want to go back to the decision tree?
Why don't you just
Yeah,
run through
someone
that?
said great flow chart, Keith. So let's jump
thanks.
into that.
All right. You guys are probably already reading it before I even get to it. But
let me
so again, I put it kind of a warning at the top left about this only applies to Baldoni's defamation countersuit. So we're not talking about his ability to defend the SH claims. So
Just to be clear on that, because there was so much confusion on that, Keith. He can defend himself, and 47.1 has nothing to do with his and the other plaintiffs' right to defend themselves against the SH complaint.
yeah, so you can defend yourself all day long and you're never going to be hit with 47.1 or the damages under 47.1. It's
Okay.
only the affirmative countersuit for defamation that triggers it.
Okay.
So will Blake Lively's 12b6 motion be granted or denied? We'll do the easy one. If it's denied, Baldoni's countersuit against Lively for defamation continues. If it's granted, okay, this is a 12b6. The court will likely grant leave to amend
To Baldoni.
to Baldoni and the Wayfarer party. So they'll have a chance to give it another shot, put in some more allegations. Baldoni will file a second amended complaint. And then what happens? Baldoni's countersuit against Lively for defamation continues. So
Unless after he files a second amendment complaint, what's naturally going to flow from Blake
there
Lively?
could be another 12b6, and maybe there's some other problems that we'll have to evaluate at that time. But usually, in a vast majority of cases, these 12b6 motions do not stop a lawsuit. They do sometimes. I mean, there are some limited instances when it happens, but that's kind of the decision tree for this motion, so that everybody understands what we're trying to say.
Then, Keith, you also put together a conflict or choice of law flow chart. Let's walk through that.
Yeah, and this just exemplifies what we've already been talking about. So is it New York or California law to apply? So if it's New York, now New York does not have, obviously, California Civil Code section 47.1. We are not New York lawyers. I don't know if they have something similar, but they don't have at least the California provision. If it's California, then California Civil Code 47.1 applies. And then the question becomes, are the SH communications made with malice? If yes, then SH privilege does not apply. If no, then SH privilege does apply. And so that's kind of simplifying the whole thing.
And then let's finally, if SH does apply,
These are the risks.
these are the risks. And why don't you walk through those for us?
So what happens if Baldoni loses his defamation countersuit under California law 47.1? He must pay Lively's attorney's fees and costs. He must pay Lively treble damages, and he's liable for punitive damages. They may or may not be awarded. There's another section that you have to go to for awarding punitive damages, but this is a one-way street, Baldoni only.
Yeah, and he would only have to pay these if he's successful against her. He does not get attorney's fees and costs. He does not get treble damages.
No.
He does not get punitive damages. Now let's put some context to what these are. And we're not going to be 100% perfect on these, but I just want to have the jury pool give them a flavor for what these damages are. So let's say the attorney's fees and costs, in this case, on the defamation, because it would only apply to the defamation, only apply to the attorney's fees and costs pertaining to that claim. But let's say a year of litigation in federal court, depositions, experts, everything else that's been going on in this case. I mean, you're easily talking $5 million.
I would think so. I mean, I've seen estimates that Johnny Depp spent $5 million on his lawsuit. And this one is even more complicated because just the sheer number of parties and the issues. I'm thinking you're probably 5 to 8 million.
Okay, so let's say 5 million just to be conservative. And then if you have to pay treble damages on that 5 million, what does that 5 million turn into?
15 million.
15 million. So you're going to multiply it by 3. So it's 15 million. And then for punitive damages, those really don't have a lot to do with the attorney's fees and costs and treble damages. They have to do with punishing a person for bringing this case. And Steve Sarowitz is one of the plaintiffs here.
Yeah.
How do you punish a billionaire with punitive damages? Let's say if I say to you, Steve Sarowitz had a $10 million damage award for punitive damages against him as a billionaire. Is that enough to be punitive damages?
Probably not. I mean, for somebody, I don't know how many billions Horowitz has, but let's just say he has 10 billion. A $10 million punitive damages award against somebody with 10 billion is not going to be much of a punishment relative to their net worth.
Yeah. So punitive damages, think about those as the court really smacking your hand really hard with a ruler. It really hurts. Okay. They're not going to kill you, but it's very painful. And to make it painful, they have to inflict pain, unfortunately, for punitive damages. So if somebody's a billionaire and you take 10% of their money, is that enough?
I don't know.
Is it 20%?
Yeah, it's hard to say. I mean, that's ultimately the jury is going to decide. And then a lot of times there are somewhat limitations that the court will impose based after the jury decides. There's different, what they call load factors and things, but it's got to be a high number. And we're not, neither one of us want Baldoni to suffer any of these things.
Absolutely not.
But we're just pointing out what the risks are, and they're significant. They're significant risks that he has to take on.
So any lawyer, in my opinion, and again, everybody's trying here, so I'm not going to say that anybody's being disingenuous here, but any lawyer that says this is not a big deal, I have some concerns because I think it is a big deal. I think that, and I don't want to belabor the point, but Justin Baldoni, let's say he's worth, I don't know, I know he wasn't worth a whole lot before this movie. Let's say he's worth $50 million today. And again, assuming that punitive damages come about. We're not saying they will, but it's something you have to consider. And if punitive damages came around for a guy with $50 million, $10 million, that's a pretty good punishment. It's painful.
Yeah.
So that's why I'm saying this is a game changer. The 47, we're both saying it's a game changer, 47.1, and it doesn't end at the 12B6 analysis.
No, it even when he gets past the motion to dismiss and the lawsuit continues, it's still something that Baldoni has to contend with, and it's a risk factor he's taking on. And the thing that concerns me is that Baldoni could win, and I said this before, but I'll say it again. He could win in his SH complaint that Lively brought against him. He could put on a wonderful defense and he wins hands down. But even after doing that, if he loses his countersuit for defamation against Lively, those damages we just looked at kick in. I mean, you could win and lose big, even though you won.
Let me just say one final thing on this, then we want to answer your questions. There's businesses in California. They say businesses are leaving California because it's very expensive to do business here. And it's some of these laws that are making businesses leave because they have to face these issues. And when these businesses are sued for SH by an employee, let's say, and let's say there's no real merit to that employee's lawsuit. The employee just is mad that they got let go or whatever the case may be, and they turn around and sue the employer for SH, and they make some claim about SH. Most employers are advised by their defense lawyers in California to do what? Fight it all the way to a jury trial or what?
No, I mean, the state of affairs now is you're encouraged to settle because the risks are so huge. And, when you don't have a billionaire backing you up, those are very big risks. And really what California is saying is when it comes to SH claims, go ahead and defend yourself, but we don't want people making countersuits, filing countersuits for defamation. That's what we don't want. And that's a policy consideration that the California legislature made. And again, you can see instances where that would be very favorable to somebody who is a victim and who needs that protection and help. But you can also see instances where this is not good.
It can be abused.
It can be abused. And that's just the reality of the situation. But let's not pretend that this law doesn't exist. This law exists. And so, we have to consider it. Are we going to go to questions?
Go ahead.
So before we get into questions, I do want to point out that we were contacted by Zach Peter, and he's doing a really great thing where he is trying to support, or not trying to, he is supporting the No More Foundation. And he's raising money for the No More Foundation to help end DV and SV. And he's launching a new limited edition Mommy Sleuth and Daddy Sleuth t-shirts. They're available through April 11th, and he's giving a portion of what he makes from those t-shirts to the No More Foundation. So we would highly recommend and suggest that you visit his merch page. We'll put a link in the video when we're done here, but the website is nofiltermerch.com, and pick up your Mommy Sleuth and Daddy Sleuth t-shirt. Zach told us that he's sending us a couple of shirts, so we can't wait to get them and wear them.
It goes for a good cause. And I think Zach, I don't want to speak for you, but I think he's giving 50%.
Okay, that's what I thought too, but I didn't want to say for sure.
I think he's giving 50%. And I think he's also pointed out that you don't make a lot of money on, maybe, I don't know. I've never sold merch, but he says, merch is just kind of what you do to get your name brand out there. But it's nice of him to be willing to do this. And it does go to a good cause. We've not done a lot of analysis of this charitable entity, but we did enough to look at it. It does look like they do good work.
Yeah. So head on over to nofiltermerch.com. We'll put a link below. Don't just listen to me.
By the way, I think he was going to get the link out on Monday, and so he not only brought it out early, but now we've brought it out early as well. So you're welcome, Zach.
Yeah.
So, by the way, we don't have any arrangements with Zach. We don't have any agreements with Zach. We don't get anything. We're just throwing that out there.
Yep. Yeah, that's it. It's nofiltermerch.com, and we'll link it in the video description and everything. Here's, I feel like a common theme that we've seen. Longhorn Cheek says, I understand the law, but I don't agree. And that's what we talked about off air. It's like morality versus legality, and it's tough.
Yeah.
What do you think about that?
Well, I've got a whole list of laws I don't agree with that, we have to live with day in and day out in our practice that I don't care for. But again, as a lawyer, you have to play the hand you're dealt. And so we don't get to change the law. We have to deal with what is presented to us.
Yeah. One thing you can do to change the law in California is you can do an initiative. That's hard work, but you can do it.
Or get out there and vote.
That's how you can do it very easily. So, yeah.
And along the same lines, this was from way earlier, but I saved it. Swarna Helena says, how does California make sure 47.1 law is not abused? I know it's a new law, but kind of what you just said.
Thank you, Swarna. And this is what Keith just said, and we'll say it again, and we don't mind saying it again. And that is, the laws are made in the infinite wisdom of the legislature, and they cannot be only given to a certain group. Well, they can at times, but here in this case, they've got to be given to everybody. Everybody should have the right to use this law. And I think what you're getting at is, man, this lady appears to be very wealthy. We think Blake Lively's very wealthy. She's very famous. She's married to a very wealthy husband who's also very famous. And why is she being able to find this? And what people are calling it is a loophole. This is not a loophole. This is a law that is being used in a very effective manner, I might have to say. I don't agree with the law necessarily, because I think there's times where it's not appropriate. But the way it works in California right now is, if you make an SH claim and somebody sues you for defamation, no matter what your background is, you can use this law to your benefit.
I would say, though, that the law does attempt to prevent abuse by making it qualified. And so it's not an absolute privilege. It is a qualified privilege. And so there is this exception of without malice, and you do have to have, at some point in time, a reasonable basis to file a complaint for SH, whether it's filed or not. So there's a couple, those things that everybody's talking about, that everybody's arguing about, that everybody's asking, can the jury find this? Those are put in the law in theory to prevent abuse.
Yeah, and Keith, I looked up Section 47.1 and Section 47. So Section 47 has been around forever. Yeah, and that's the litigation privilege. 47.1 is this enhanced SH privilege, and so there's just not a lot of case law out there. The 47.1 was passed in October of 2023 and became effective in California January 1 of 2024. But 47's been around forever, because the litigation privilege has been here for a long time. But I did look under some of the cases in the litigation privilege, because there are a lot of case law that's already been decided under that. There's not a single case in California right now that's been decided under 47.1, because it's such a new law.
Brand new.
There's been a lot of people writing about it, but there hasn't been any case law. So we'll have to wait and circle back when an appellate court actually has to deal with the law. Maybe this judge that deals with it the first time. Yeah.
Baldoni versus Lively.
But the thing is, under Section 47 for the litigation privilege to attach, there is some cases that say you cannot use the litigation privilege. You cannot sue somebody without probable cause. In other words, without being reasonable, just in order to obtain the privilege so that you can harass them or defame them. So there's a whole list of cases on this point. And so the idea is, I think this is what some people in the jury pool are so uncomfortable with. They believe that Blake Lively did all these things as a kind of in gamesmanship in order to get the privilege so that she could defame Justin Baldoni. And then they're upset that he doesn't have a right to sue her because they feel that she has wronged him. And so there is some line of cases out there, and this may be where Brian Friedman ends up going. And basically, I'll read the sentence to you. Litigants may not institute suit without probable cause, which we would say reasonable cause, for the purpose of obtaining a privilege, this litigation privilege, to harass or defame others. So that's out there. Keep in mind that you also can zealously advocate as a lawyer and as a party to a lawsuit. You're allowed to zealously advocate. So the question is it zealous advocation on your part, or is it without probable cause?
So Baldoni can sue for defamation. It is a qualified privilege, not an absolute privilege, but there's a huge risk he's taking on in doing that. And he has to, just hope that a jury, ultimately, if this goes all the way to jury trial, that a jury agrees that Lively spoke, with malice, and she did not have a reasonable basis. That's what he needs the jury to decide. And
if the jury decides that in his favor, then many people in our jury pool will be happy because they will see that justice for Johnny Depp.
Yeah, right. Exactly. But that's what you need. And it's an uphill battle. This case would not be the same 2 years ago.
Okay. Can you give an example of malice being proven in defamation?
That's a good point. I mean, we put up the definition of malice.
I'll put it up again.
We should probably look up a few cases where it actually worked, where it's actually proven. It is rare. It's a rare thing to see, like when people sue. Well, I guess no, because that case you mentioned a case with Giuliani. I'm not sure that was malice, though, because those they were two public people. I'm not sure if that was malice or not.
Yeah, it just comes down to, and what we'll do is we'll circle back to that question and actually pull some cases from California where actual malice has been found. There's also a jury instruction that explains actual malice and explains to the jury when they're deliberating what they can look at to determine if actual malice has taken place. But what I really think it comes down to is a jury's going to sit there, they're going to hear all the evidence, and if they have a negative feeling towards somebody, I think they're going to find actual malice. If they don't have that negative feeling towards that person, they generally don't find actual malice.
Right.
But yeah, good question. That was from All for One Sound. So we'll have to circle back on that and do a little more research. Here's another kind of what you guys were saying. We had a jury pool member say, I don't know how they're going to find 12 jury people that are neutral with this case. It's impossible. And yeah, it's like, do you get someone who's never owned a TV or something like that? Watched a movie?
What do you think?
Yeah. You look under rocks. The people who've been living under rocks. I mean, New York has millions and millions of people, and there's a certain segment of the population who have not been paying attention to this. Those are ultimately the people who are going to fill in on the jury. So,
and there's people that could have heard of the case but don't have an opinion on it one way or the other. It's okay that they've heard of it. The real question is, can they be impartial? And that's really what a judge wants to know. Can you be impartial to everybody? Can you be fair?
Yeah.
And if people say, yeah, I can be fair, then there's a chance they can be on the jury.
Yeah, you just go door to door and find everybody who doesn't have a TV or a computer.
Does the judge get to decide if she can use California law?
Yes.
Yep. Here's a good question to break things up from Alice Knows. She says, my son is almost 16 and wants to be a lawyer. As a high schooler, what advice can you give that would help him see if the law is a good fit for his profession one day? Thanks. Thank you.
I would say that writing is probably the most important aspect of being a lawyer, writing clearly. And so I would say a lot of reading, just a ton of reading. Doesn't matter if it's fiction or nonfiction. And then doing a lot of writing, report papers, put your thoughts down on paper. What do you think?
Yeah, I think so. And then if you can find even, a smaller firm to intern with, even if you're just making copies or whatever, just be around lawyers and see what they do and listen into what they're doing and see if it sounds interesting to you. I mean, I have one son who wants to be a lawyer and is applying to law school because of being around both of us for 20 years. And I've got another son who's like, I never want to do that. so it's not for everybody. And that's fine.
Priya says, and I think this is what we got to in your flow chart earlier, but she says, can JB amend to apply defamation to Ryan Reynolds and not Blake Lively?
Yes, he can. Absolutely. And, I think the problem with the Ryan Reynolds part of it, and we looked at his opposition, is the allegation that Baldoni has that Ryan Reynolds called him a sexual predator. mean, that seems pretty harsh. So, yeah, that's what we were saying earlier, is that Baldoni could amend his complaint and say, okay, fine, I'm only going to sue Ryan Reynolds and Leslie Sloan and New York Times for defamation and not libely.
Yeah. And do you think that Ryan Reynolds had actual malice if, in fact, he did tell somebody that Baldoni was a sexual predator?
I mean, it seems like it. Yeah. I mean, there's certainly grounds where a jury could find actual malice.
Yeah. I mean, I hate to say it, but as a lawyer here looking at this, I would say, look, there's some issues with the Blake Lively complaint for defamation against her. Maybe you can get it through. Maybe you can't. The point is, Ryan Reynolds potentially still on the hook. There is the anti-SLAPP statute in New York. We don't know if that applies to him or not. The New York Times, I'm still up in the air on that. I kind of feel like the New York Times may wiggle their way out of this
because the fair reporting privilege.
The fair reporting privilege is pretty strong, especially under New York law. And if California law applies, well, maybe they'll have a much more difficult time. But Ryan Reynolds, and some people say he's the worst actor in all of this. You still have a claim against him, and he's got deep pockets, and you can keep the case going. And he's married to the person that you ultimately want to come after anyway. Yeah. So
you called him the worst actor. You mean like worst party?
Did I say the worst actor?
You said he's the worst actor.
I didn't mean actor in Hollywood. I meant the worst actor in this case. Yes.
Double meaning.
No, he's a decent actor. So.
It is interesting, isn't it? Interesting though how California law actually benefits Baldoni as against the New York Times, because the fair reporting privilege apparently isn't as strong, and you have some other causes.
It's
of action.
Stronger here.
Well,
it's his. Yeah, I'm sorry.
Yeah.
You said it correctly. I apologize.
Yeah. And there's other causes of action, and yet California law is kind of more painful on the lively front. So it's interesting, and this is where strategy comes in. The strategy is so important,
right?
Because you have so many different moving pieces and moving, parties here,
right?
When does the extortion and movie theft kick in, and would that support malice? I mean, we're all kind of going over the hypotheticals, but
it could. I mean, it could. I mean, they're going to do anything they can to show that she had actual malice towards this man. And if she had actual malice in the way that she reported the SH, if she had malice against him and hatred for him, and did not truly believe that she had claims for SH, I think that's what he's going to be showing.
Yeah, as soon as we saw the malice in 47.1, the thing my mind jumped to is, but she stole the movie, and that's the allegations. And so that seems like there'd be an ulterior motive, which could point to malice.
Yes.
Okay, I had to just look this up really quick. Falsus in uno, falsus in omnibus.
In everything.
You guys know what that means?
False in one, false in everything?
Yeah, false in one, false in everything.
Yeah,
you got it.
That's the jury instruction.
Who wrote the rooftop scene, both from Blake Lively? I think this kind of just is talking about Blake Lively and her character. But
yeah.
Is this the same law that 90 women used against Harvey Weinstein?
I don't believe it is, because it became effective January 1 of 2024, and I think his case has been done for quite some time.
I think the law that you're thinking about, the 90 women, that's the one where they extended the statute of limitations to allow SH claims to come. It broadened the statute of limitations for bringing old SH claims.
That makes sense. All righty. Kirsten says, I'd wear Ask Two Lawyer shirts too.
We're working on it. Where are they, Eric? Come on.
I'm just, I'm trying to, I don't know.
He's
I got
no
excuses.
Here's the problem. Producer Eric's a perfectionist. And so he's been working on some designs, and I keep telling him they look fantastic, and he's just never happy because he's trying to make them perfect.
Can we go back to the CRD complaint just a little bit here, just real quickly? So let's look at these privileges again. We've got the reporter's privilege, and we've got the litigation privilege, and there's different things that happen under each privilege, and we've got the SH privilege. So if the CRD complaint had never been filed, it's true that the SH privilege would still apply.
Yeah, any communication,
and nothing has to be filed. So when we get all up in arms about, but the CRD wasn't complied with, there was this 30-day requirement, the right to sue letter, we have all these issues, does she demand to, for the 24-hour, I have the right to sue? I mean, all of that kind of goes out the window if you analyze this under 47.1.
Yeah. You have to put all your eggs in one basket. You have to attack malice. That's where you're going on the Baldoni side.
But then when we talk about the litigation privilege, we really do need something filed at that point in time.
Yes. And that's why 47.1 is so earth-shattering. It opened the door in a big way, because before it had to be an official filing under 47.1, it only has to be a communication.
And then we have the fair report privilege under 47D.
Yeah.
And that goes both ways now, right? There's not only is the press, as long as they're accurate and truthful and kind of in the ballpark when they report about this, anybody that delivers information to the press falls under the fair report privilege, right?
Yeah, and that's where they, in Lively's opposition, they were calling it the bridge. There's a bridge between the report, or, the communication or the report that's made and the New York Times reporting it. And the bridge is giving it to the New York Times is also covered. So it's really interesting how it all, kind of shuffles together here.
Yeah, I mean, we just got to an hour. What do you guys think? Do you want to? And we answered a lot of questions. I'm sorry if we missed anyone's questions, but you guys want to put a bow on this? And
well, it's our hope really that the jury pool can take the information we've given, and again, we're susceptible to error. We're susceptible to making mistakes. Take this information. Let's debate it. Let's talk about it. Let's look at it. Everybody get out there. The mommy and daddy sleuths get out there and get into the California law, get into New York law, try to wrestle with this stuff. We ask juries to wrestle with this stuff. Why can't we ask you to wrestle with this stuff? So let's look at it. Let's make each other better. Let's lift each other up. Everybody's trying hard here. Again, I don't think that, if you disagree with somebody, be kind about it. If you agree with somebody, be even kinder. But we can all work together to get to the bottom of this. I really appreciated Zach's comments yesterday.
Yeah, it's funny because there's only one person who gets to be 100% right in this leading up to trial, and that's Judge Lyman.
Yes.
He's the only one who gets to ultimately make the decision. So the rest of us, we're sitting on the sidelines and we're doing our best to handicap the different results. But yeah, nobody's going to be perfect.
all right, a couple more that just came in. Beverly, thanks for you for the support. And maybe we'll just pile on to know more for what Zach's doing for his donation. But thank you for the support. Beverly says, does Ryan Reynolds and Blake Lively mocking, trolling, killing JB and the nice pool thing in the credits support Malice? Again, all these hypotheticals. Maybe it will, maybe it won't.
I think it helps. I
Right.
mean, it goes there. At least it's some evidence that goes towards it.
And MC High Life, thanks for the support. Will Ryan's message to Justin, where he claims to adore him, factor in being as he didn't see Justin as a predator in the beginning, or is that not relevant?
Well, I mean, I know, I think we're talking about text messages that went back and forth between Baldoni and Ryan at first, and Baldoni was very nervous about texting him. And I think the relationship started out nicely, but Keith and my relationship can start out nicely. And then 6 months later, I could be running around calling him a sexual predator. He could be calling me a sexual predator. And now you're damaging one another's public persona and who you are as a person. And you're damaging your ability to be respected by your community and the peer members. And so I've been damaged. I can sue you for that. And I think that's what's going on here.
Yeah, that's right. And not only that, but when you have a message where Baldoni's trying to reach out to Ryan Reynolds and be nice, and then ultimately Ryan Reynolds, makes those statements allegedly, I think it does show a certain, malice potentially to a jury.
Awesome.
Oh my gosh, Ashley. What does Ashley say?
Whoa.
Thank you, Ashley. We really
Says,
appreciate
I love
your
listening
support.
to you guys, so knowledgeable and clear in your in your discussions. Excuse me. I forget if you mentioned if you're still practicing lawyers. If I need help with my own SH issues at my employer, sorry to hear that. Would you help consult with any of your listeners?
Anybody in California wants to reach out to us. We do not do SH law any longer, but we would be happy to, without any remuneration on our part, get you to the right lawyer that can help you out. Absolutely. Ashley, sorry to hear you're going through that.
Well, geez, we're kind of all over the place, but again, recap, put a bow on it, cut it off. What do you guys think?
Well, I mean, I think we've covered this issue twice now. Hopefully we've clarified it and made it a little bit more understandable. Like we said at the beginning, we have complete and utter faith in our jury pool that you're capable of hearing the good and the bad, the pros and the cons. And we're going to keep doing that. That's who we are. And as lawyers, we have to do that. We have to turn the crystal and we got to look at all sides of all the issues. And I think there's a lot of people out there who appreciate that. And we really appreciate your support.
All right. Till next time, keep debating this. Keep your comments coming. And we'll see where this case is huge. It's just going to
There's more coming. We haven't even talked about.
And we got Shesty tomorrow?
Oh, yeah, that's right.
I kind of forgot.
Yeah.
I think we're going to be on Shesty. I
Yeah.
don't understand her name. I need to work on her name.
Shesty Fla.
Okay.
Is it Shersty? I think there's an R in there somewhere.
It's in it, but I don't think it's a silent R.
Okay, somebody will help us
We're
out
so
in the chat.
bad.
I know
We're
it's
so
bad.
bad at
We
this.
love her.
We gotta
we,
get
we
better.
really like
I
her.
know
Yeah.
she's fantastic,
Yeah.
but we're just not good. You know. Anyway,
Yeah. All right,
thanks
guys.
everybody. Have a good Sunday.
Take care.
Yeah.